Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to circle back now to a really big case that is pending petition before the United States Supreme Court. We have geeked out on this case before. Has to do with an absolutely insane gun law coming out of the state of Hawaii, which, of course, the Ninth Circuit found absolutely no problem with. Today, we're going to focus on an amicus brief that is filed by one of our favorite authors around here. Of course, that is Mr. Barry Arrington over at the National Association for Gun Rights. And listen, he really takes a swipe here at what's going on with your rights. So today, let's spend a few minutes and let's talk about the Supreme Court argument that pulls no punches. Okay, America, we are talking about a case that we have talked about before. In particular, we're going to be talking about one of the amicus briefs, which is filed in support of petition for certiorari before the United States Supreme Court. The case we're talking about today is Wolford v. Lopez, a challenge to Hawaii's crazy law that you cannot carry a firearm onto any private property which is held open to the public unless you have express written permission from the property owner, which translates to an island-wide ban. The issue that Mr. Arrington has chosen to kind of laser focus this brief on, and this is a huge issue. This is a huge issue, not for this case, but for all Second Amendment cases, is this. When we're trying to determine whether or not there are historical precedents that can support gun regulation, do we look to founding era law? Do we look to Reconstruction era law? Is it a combination of two? And if so, what is the proportion of that combination? Because here's the problem, America. The more that courts can rely on Reconstruction era law, the more they can, with a straight face, attempt to justify these gun control regulations from a historical context. But what I want to focus on today, and it's the reason that I really love Barry's briefs, is because, well, there's a tremendous amount of sarcasm here. And we here at Washington Gun Law are huge fans of sarcasm. For example, progressive constitutional jurisprudence is, to say the least, odd. Take, for example, progressives' attitudes toward the fabricated right to abortion and the actual right to keep and bear arms. The Constitution does not refer to abortion, and no such right is implicitly protected by any constitutional provision. In contrast, the Constitution specifically enumerates the right to keep and bear arms and unambiguously states that it shall not be infringed. Yet progressives treat the fabricated right to abortion as a super right that is more sacrosanct than the rights actually enumerated in the text. At the same time, they insist that the actually enumerated right to keep and bear arms does not really exist in any meaningful sense. Now, that is an incredibly true statement, but one that you don't often get to read in Supreme Court amicus briefs. But he's not done there. From this, we can conclude that the text, history, and structure of the Constitution are simply irrelevant to a certain kind of judge if they stand in the way of achieving the judge's preferred policy goals. And of course, Mr. Arrington points out that, this is an ongoing battle that's been occurring now for nearly 20 years as they've been just trying to chip away at this. In Heller, the non-originalists lost the fight to drum the Second Amendment out of the Constitution. Having lost that fight, they have spent the ensuing 17 years frenetically working to undermine Heller as much as possible. And in the Ninth Circuit especially, they succeeded famously. God, I absolutely love this brief. But here's the problem, and as the author points out, the latest tactic that anti-Second Amendment forces have employed to undermine the right to keep and bear arms is to argue that 1868, as opposed to 1791, is the proper time period for judging the scope of the right. And listen, even though this case is in an interlocutory fashion, which means that the chances of the Supreme Court really accepting this review are pretty remote, Mr. Arrington points out here that, hey, listen, the way the Ninth Circuit's doing this thing here, we got a complete circuit split as to what is the history that we must rely upon, as he wisely points out. As noted in the petition, there is a circuit split as to whether it is permissible for courts to place primary reliance on Reconstruction era and later laws to uphold modern gun control regulations. It is vital that the court resolve this split at the earliest possible time because it has significant ramifications, not only in the specific context of Second Amendment cases such as this one, but also in a host of other constitutional contexts. And then in support of the petition itself, the author of the amicus brief correctly points out the Ninth Circuit's approach leads to two radically different Second Amendments existing at the same time. You see, that is true because now we have circuits that are predominantly or exclusively relying on founding era history, and we have the Ninth Circuit that's doing quite the opposite. And so, therefore, what is protected is going to change significantly based upon the circuit you're in, which is not a newsflash to any of you, but they are actually bastardizing the Bruin test in order to achieve those results. The amicus party further argues the text of the Second Amendment has never changed, and yet the history that supports it seemingly changes depending on what day of the week it is and which court we're in. They also point out the scope of a right is pegged to the public understanding of the right in 1791. I mean, when you think about it, what is the public's understanding of the right? Wouldn't we take a look at the time the right was established, or in this case, the right was codified in the Constitution? Because let us remember that the Second Amendment doesn't actually give us the right. Our Creator gave us the right. Second Amendment just says government can't take it away from you. But then Mr. Arrington goes through and points out that, hey, listen, this history has never changed with any other constitutional amendment. For example, First Amendment religion cases, Espinoza v. Montana Department of Revenue, First Amendment speech cases, Nevada Commission on Ethics v. Kerrigan, the Fourth Amendment, Virginia v. Moore, the Fifth Amendment, Gamble v. United States, the Sixth Amendment, Crawford v. Washington. And ultimately, if you really want to summarize what can happen to your constitutional rights if courts are permitted to rely on the incorrect historical period, it's this. Later history can liquidate an understanding of the text, but it cannot change the text. So like I say, America, this is a really good brief. I appreciate the way the author came at it. I really appreciate the way that NAGR, when they do amicus briefs, are not doing big old dittos. That is, just saying something that a bunch of other people have filed briefs on as well. They find very niche issues, and they go in there with a scalpel, and they really, really analyze them well. And this is a very, very important consideration because, candidly, this deals with the future of how any other gun control legislation is going to be analyzed moving forward. We're going to go ahead and put a link for the brief down below so that you can geek out on it. We're going to put a link down below for NAGR so that you can show them some love. This brief throws a lot of haymakers, and they should be commended for that. Listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool, let's hear about it. Just click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.